Welcome to EPG Pathshala. This paper is the philosophy of law. The current module is a history of Hindu law. The objectives of this module are to understand Hindu law in the context of its history and evolution. This module was written by Garima Goswami, an independent research scholar in New Delhi. I am Akash Singh Rathore from the Lewis University in Rome. Hindu law is basically family law. It's attached to persons in whichever context they take, public or private. That attaches not only to self-professed Hindus, but also in some respects to Sikhs and Jains. Now, how did Hindu law come to be personal law or family law? This is a very interesting evolution, because if we go back over the thousands of years of Indian history, what we find is that Hindu law has existed in various forms and scope going back to at least Vedic times. In the Indus Valley civilization, we can understand this region to have been governed or ordered by some aspect of what we could vaguely refer to as Hindu law. And thus, from going to a way of organizing vast terrains of territories in all respects, that is, criminal, civil, political, economic, family, and personal, going from organizing an entire civilization down to just representing personal or family law, is a curious evolution that this module hopes to trace in some significant markers. Now, Hindu law has often, throughout Indian history, been limited in scope or dilated, expanded in scope. You can think of various regimes or empires or political dispensations that have either deployed wider aspects of Hindu law or narrow aspects of Hindu law. And this stands from the Mauryas to the Mughals, each of which had secular courts and secular institutions, as well as the permeated cultural environment of Hinduism, which impacted the way that people conceived of the law and how to live their lives. Within the history of philosophy in India, whether it's Nyaya, Vaisheshik, Sankhya, Yoga, Mimamsa, Buddhism, Jainism, and so on, all of these various philosophical schools have also had their own orientations toward the legal framework, or what should be considered law from a normative as well as a positive point of view. What should be law and what is the law in fact. So we have, on the one hand, diverse historical epochs and experiences with Hindu law as being wide or narrow, as being controlling or merely influential. And then we have the philosophical take on the nature of law in India, or as we more broadly, generically refer to it as Hindu law, whether that should be positively, normatively implemented as positive law, or what is the status positively. So all of these different perspectives and considerations about the wide history of Hindu law come to be important in this slow evolution of Hindu law as being the basically the law of the subcontinent several millennia ago, to what is in the current time just a small aspect of a much broader secular legal framework that covers personal and family issues. This module is going to trace that history in its most salient aspects. So let's start by discussing the relationship of the ruler or king in Hindu law. Hindu jurisprudence, or more specifically classical Hindu law, is quite different from its European counterparts. This is because obedience to law was not primarily due to authority of its arbiter. The commands found in the authorless divine texts, such as the Vedas, were revered. The law was interpreted from these and explained to the general public. The interpretations of these texts were quite frequently in conformity with the belief of the authority of the Vedas among the theistic schools of Indian philosophy, which gave classical Hindu law a universal appeal. In classical Hindu law, there is a distinct relation between law and politics. One of the reasons for this can be that there was a distinct scheme of values. Moreover, unlike in the West, where the king is the sovereign, in classical Hindu law, the king too had a dharma, or a duty, which was known as the Raja Dharma. What this suggests is that the king merely gave political sanction to laws written by private individuals based on the interpretation of the religious scripture. A just ruler was also a good judge who often arrived at verdicts seeking the assistance of his council, which included philosophers or even religious ascetics. However, most cases rarely reached the king's court and were sorted out within small communities or groups well in advance. While the king was given the responsibility to ensure social stability by observing dharma, it was his sacred duty to ensure the dispensation of justice. If, however, there was any miscarriage of justice, the ruler responsible for it was liable to get 1/4 of the sin. So let's discuss classical Hindu law in some detail. While it's true that classical Hindu law was based on religious, or rather sacred, philosophical texts, scholars of the texts therefore played a crucial role. In actual practice, it was both decentralized and diverse, and it differed from community to community based on the different locations, the different vocational groups, and of course the caste. While it's true that classical Hindu law was based on religious, or rather sacred, philosophical texts, and scholars of these texts played a critical role, in actual practice it was both decentralized and diverse, and differed from community to community based on different locations, vocational groups, and castes. According to Werner Menski, Sanskrit does not have a single word that means law. The word dharma in Sanskrit, which is equivalent to dhamma in Pali, is what is used for law, but etymologically, these terms derive from dhri, which is mean to hold together. So dharma is meant to hold together the human race. Its meaning is multifarious and is used to mean duty, morality, obligation, and law, and need not have only a religious basis. So the sense that we find here is that dharma can translate law, but is not exclusively identical to it. Dharma comprises court procedures and activities such as regimes for personal hygiene, ritualistic purifications, and so on, apart from law. The mistake most scholars make, according to Werner Menski, is to search for a definition or a final concept of Hindu law that's modeled after the understanding of European law, particularly the search for preferably codified forms of state-made rules. Werner Menski believes that the purpose of ancient Hindu texts is to offer guidance for negotiating dharma and not to lay down state-based fixed rules. It's one of the Purusharthas, the objective or guiding principles for men by which human beings are supposed to lead a systematic, and disciplined life. Now, according to another scholar, Ludos Rocher, the Sanskrit term vivad corresponds to substantive law, and the term vyavahara corresponds to legal procedure. These two are terms that meet with a great deal of ambiguity, and there's a lot of argumentation about whether these words can be fixed to mean the definitions that we attribute to them. So there are different meanings like doing, performing, conduct, action, behavior, or practice that can get interpreted as constituting former legal procedure. But Werner Menski thinks that what we find when we identify these terms is once again the attempt to reduce or remove the context of Hindu law and turn it into a different location of the way European law works. Now, Werner Menski believed that, and I quote, "Law is never a given and must be constantly negotiated." And in this respect, the concept of dharma got it right for its consciousness of plurality. That's a main feature of Hindu law. Now, let's turn to some of the sources of law. There are basically 3 sources of law that we can understand: Shruti, Smriti, and Achara. Of these 3, the ultimate authority is the Shruti texts, which include the Vedas and are said to be of divine origin. In fact, Smriti and Achara, which are man-made, get their authority or derive their authority from the Vedas or the Shruti texts. In case of any dispute, the words of the Shruti texts are considered authoritative. However, according to Renamensky, once again, there's hardly any dispute between Shruti and Smriti. Now, the way that these terms Shruti and Smriti are used, it tells us that the orientation is towards one's own good, one's own inclination, and one's own motives. In other words, it tells us about the way that we interact with our dharma. This suggests that the sources of Hindu law are Shruti and Smriti. Shruti means what is heard, while Smriti refers to what is remembered, and these are either written or unwritten. And in all cases, they reflect or refract what we refer to as the Dharma. According to Donald Davis, sacred Indian texts were rarely used within the Indian legal system in the administration of law. So this is a very different view from Mensky's, but Davis is referring to administration or application of law rather than the identification of its nature, which Mensky has more closely in mind. Now, although there's no single positive precept which could be used as a rule of conduct within the Vedas, according to Dharma Shastras, the Vedas are the root of the Dharma. Shruti comprises ancient Sanskrit texts and includes the Vedas and the Upanishads. The Vedas are 4 in number, as we all know, the Rig Veda, Yajur, Sama, and Atharva Vedas. These are divided into different hymns and rituals and branches and subdivisions and so on. So where is it that we actually find what we refer to as Hindu law? Well, if we look at the classification of the Shruti and the Smriti texts, we discover that a number of them have main clauses and so on that seem to be the foundation of law in Hindu jurisprudence. Well, we had already mentioned that the Smritis derive their authority from the Shrutis, and as Smritis are written by humans and come with a divine sanction, they incorporate the rules of conduct for everyday life in view of the customs followed in society. The Smritis include commentaries, digests, and Puranas. They can be further classified as primary and secondary. Sutras are primary Smriti texts. The primary ones include, of course, the Dharma Sutras, which are important in the foundation of Hindu law. In this module specifically, we are concerned with the Dharma Sutras. Dharma Sutras means a string or thread of righteousness. It's written as prose, and the texts are guidance on Dharma with steps to be followed for the rites and the rules of conduct. Now, the way that these Dharma Sutras describe the sages of life and the other topics like the duties of kings, the right to be performed by kings, and the court procedures to be followed, information about crime, punishment, sacrifice, rituals to be performed at funerals, and the correct diet to be followed, and so on and so forth. These are what seem to constitute what we refer to as classical Hindu law. A lot of the principal Smritis include those writings of Manu, for example, and Narada that are constantly evoked in order to give a citation or source for a specific decision about what Hindu law prescribes. Well, in that respect, the significant Smritis like Manuskriti or Narada Smriti give us the kinds of verses that we would turn to. The problem derives from the internal inconsistency of many of these Smritis. So this raises one of the first questions that we have to ask ourselves. When these are in conflict, which one reigns supreme? And this is what begins to inform us about the plurality of the idea of Hindu law. In classical and medieval India, the first order of legal discourse were the customs. So in other words, how do you decide what is the right source of law? You find out what is the customary practice in the area. According to Henry Thomas Colebrook, there were primarily 2 schools of law, and there were a number of less prominent schools like the Benares school, and the Bombay School and so on, the main schools of law were the ones that gave us primarily the theory, while the specific schools were involved with compiling customary practices. That is Hindu law in its wide, locale, and diverse appearance, as founded in scriptures, sacred texts, but as practiced differently in various places. Now the orientation switches completely with the emergence of what we refer to as Anglo Hindu law. So let's discuss Anglo Hindu law now. The development of Anglo Hindu law can be divided into two periods in Indian history. The first is from 1772 to 1864. During this period, the British adopted rules to administer justice, mostly in Bengal. The second period is from 1864 and ends in 1947, when India is finally granted independence. In the first period, judges in courts of law initially relied on pandits to interpret Dharma Shastra texts. Classical Hindu law could be applied to all Hindus. Eventually, their use became irrelevant due to the development of case law, where precedent cases were referred to. So now the British judges didn't need to rely on the advice or counsel of pundits on what the scripture said. Rather, they had their own precedent to rely upon on how to decide the cases in accord with Hindu law. Now, there was a great compilation and translation of Dharma Shastra texts during the first period. So scholars including William Jones, J.C.C. Sutherland, and Colebrook himself gave what we refer to as Hindu law its codified character. So this is a very interesting thing, because as we had pointed out in the first part, what we refer to as Hindu law was actually a great deal of customary Hindu practices that varied from place to place. And it wasn't until the emergence of British jurisprudence within India, when various Anglo judges and practitioners began to translate and systematically organize Dharma Shastra texts to come up with a codified Hindu law. Now, during the second period, the Dharma Shastra texts lost their significance in the Indian legal system, because the British realized that the idealized legal system of the Dharma Shastra was not actually connected with customary legal practices which were followed among various regions and communities. Codification of various laws and acts took place, and Hindu law was reconstituted into the modern legal system that was followed in India. So much has changed except what is known as family law or personal law. This was because the Hindus, who comprised the majority in India, followed different personal laws from the Muslims. The Hindu law applicable in this sphere was one based on customs and Dharma Shastra texts. The subject matter of modern Hindu law included marriage, adoption, succession of property, and property inheritance. Once again, we can look at what Werner Mensky says, because he provides very interesting insight into this period, since he believes that it was this period when classical Hindu law was completely misinterpreted and misconstrued. So let's quote Werner Mensky. Starting off with imperfect assumptions about the nature of law and having sought the wrong kind of expert help by asking misconceived questions of their native law officers, the pundits in their service, as they were called, the British engendered a complex process of distortion. The morass of Hindu law got deeper, and eventually the monstrous hybridity of Anglo Hindu law was produced. Well, glorifying Hindu law, or rather classical Hindu law, Mensky says, Hindu law represented a culture-specific form of natural law. It is an ancient, chthonic legal system. At the same time, as a holistic legal system, it emphasizes and instrumentalizes the intricate connection between different interlinking elements of the whole experience of human life. Hindu law thus falls firmly within the theoretical parameters of the historical school of jurisprudence. This treats legal rules as organically grown, socially tested normative orders, and therefore does not accept legal positivism, encapsulated in the claim of the state to be able to determine and enforce rules in an authoritarian fashion. Well, if that is classical Hindu law and its evolution, Anglo Hindu law, let's turn now to modern Hindu law. The end of Anglo Hindu law saw the codification of law modeled after the modern legal system of the British, except in the sphere of personal law. The Indian Constitution adopted principles of equality, secularism, socialism, and liberty. B.R. Ambedkar, who drafted the Constitution, proposed a Hindu Code Bill. His intention was to restructure laws under the sphere of Hindu personal law, where the distinction of various castes was taken into consideration. This, according to Ambedkar, was opposed to the spirit of equality and was therefore unconstitutional. Reforms suggested in this bill tried to do away with the Shastra or Varna basis as advocated in classical Hindu law, which was not modified under the British Raj as long as it formed part of personal Hindu law. There was immense opposition to the Hindu Code Bill, as many believed that it was partial, that only the Hindu laws were meant to change drastically as opposed to other religions. This development, however, was said to have been well received by the Indian nationalist movement, and much from this period was adopted after India's independence. But despite making many changes to the Hindu Code Bill, it failed to pass. Later, 4 separate acts were passed which were said to be part of Hindu Code Bill, namely the Hindu Marriage Act, 1955, Hindu Succession Act, 1956, the Hindu Minority and Guardianship Act, 1956, and the Hindu Adoption and Maintenance Act, 1956. It's noteworthy that in India, despite there being different family and personal laws for various religions, the courts are where matters are adjudicated in common. The judges who preside over legal matters are common to all communities, and they need not belong to a specific religious group, which brings forth some matter before the court of law. The judges do not have any formal training in religious studies. Hindu customs are significant only to help identify as Hindu a person to whom the Hindu law may be applicable. But as per the provisions of many acts within the Hindu law, such as the Hindu Marriage Act, it can be seen that the force of customs have been made less significant. For instance, Section 4 of the Hindu Marriage Act maintains, and I'll quote from this, "Any text, rule, or interpretation of Hindu law, or any custom or usage as part of that law in force immediately before the commencement of this act shall cease to have effect with respect to any matter for which provision is made in this act." However, as modern Hindu law is not completely codified, Mensky notes there are certain provisions for certain customs. For instance, Section 5.4 allows South Indian customs of cross-cousin marriages, while it lays down rules for prohibited degrees in marriage for North Indians. So what we've seen is this slow evolution with certain stops and starts from the ancient era up to the contemporary. What happened in that period? We saw, first of all, this conception of the religious scriptures more or less governing the entirety of the social and political life of the subcontinent. This we can refer to as an era aptly captured in the Vedic period, where what we refer to as Hindu law, of course they had no such concept at that time, what we refer to that as Hindu law covered all aspects of everybody's lives based on their different communities, their different expectations, different practices. And slowly these evolved in some respects into various literary legal traditions. So different foundations for the theory or dictates of law. But were these exactly state law? Not at all. This was a various theologically religious, sacred, ritual-based presentation of the legal sphere and legal system. Is it law as we would refer to it today? Well, in some respects, yes, because it was issued by certain authorities, backed by sanctions, and followed by most people. However, it wasn't the dictate of a sovereign by any means. What happens over time is that while these both religious rites, rituals, and expectations get written down into various further scriptures and delineations like Dharma Sutras, what we find is that over the course of history, there are disruptions of this practice. So obviously, the period of Mughal rule will serve to curtail the universality, assuming there was one on the subcontinent, of the scope of what we refer to as Hindu law. So there was the creation of secular, courtly, political regimes. And within the, as we would say, civil laws of those regimes, you had distinctions between what would constitute as expected or legally obligatory for all in all different spheres. So obviously, criminal law, civil law, and these sorts of domains, of course, they also didn't have those concepts. These sorts of domains would have been regulated by different considerations from the Mauryas to the Mughals. But the real rupture or change occurs with the period we refer to as Anglo Hindu Law. It was this large, long, turbulent period where we saw several unique events unfold. On the one hand, the British used scholarship, legal scholarship, and research, philological, historical, and textual, scriptural research, to attempt to come up with a codified version of the Hindu law. In other words, they said that a polity or community or society or a nation must be ruled by a unified body of laws. So let us find what it is for those Hindus of the subcontinent. In so doing, they were imposing, as Wiernemensky says, the conception of law within European traditions onto the way that the lived practices, social, political, and legal practices of India were supposed to be. So the British, in some respects, created classical Hindu law. They created textual law out of all of the scriptures, writings, and texts that were not, in fact, necessarily followed by the average Indian person, whether Hindu or not. Then came a second phase of realization of this problem constructed in the process of trying to create Anglo Hindu law. And what happened was that the British realized that the actual customary practices were widely divergent from the so-called codified law that they had ostensibly discovered. So in that process, the British realized that it were customary practices that were regnant in the control of people's social, political, and legal behavior. And there was a new orientation to rely much less upon the codified Dharma Shastra scriptures that the British had earlier championed, and much more focus on the actual customary practices. At the same time, these practices, as well as the codified law, were already incorporated into a history of case law and jurisprudence in British India. And in that respect, the British didn't need to rely on anything other than their own judgments in an effort to come up with what they referred to as a religiously sensitive jurisprudence, Anglo Hindu law. With the Indian independence that came, the drafting of the Constitution required a new way of integrating the sensitivity towards religious customs, rights, practices, and obligations with the demands of a secular democracy. And in that respect, the Constitution was written as supremely secular, but allowing in the personal or private family domain the exercise and practice of Hindu principles. And this was the way that Hindu law slowly, over several millennia, narrowed down to being identified or equivalent with family or personal law. So this module has shown the history and evolution, which is basically the dilation of the framework, theological, political, and legal, that used to govern the entirety of the subcontinent, to the contemporary situation, which is Hindu law as a expression of the personal law of self-professing Hindus, and in some respects other communities that are included within it. Thank you.